That's my Savannah. That's where I got from Savannah. You said the courtyard? Okay, okay. Good evening, good evening. We're going to go ahead and get started because we want to start on time so we can what? Finish on time. Well, I want to say welcome to tonight's meeting, the Open Recs Act Town Hall meeting. This is a meeting that has been in the works for quite some time, so I want to thank you ahead of time for taking the time to come out and converse with us about open records, what it is and what it is not. I want to briefly introduce myself for those who don't know me. I think I know everyone in here. My name is Corey Adams. I serve as the city clerk for the city of South Fulton, and part of my duties, one of my duties, is to serve as the open records coordinator for the city. The city has a centralized open records process, meaning that records requests come into our online system. It's distributed to the custodial department. They respond to it into the open record system, and then it's distributed to the citizen. I want to also take this time now to recognize Councilwoman Catherine Foster Ryle, whose district we're in, the fabulous District 1, Sandtown Recreation Center, as well as some of the staff here. I just want people to know who's here. I have Teresa Wilson, who's in the clerk's office. So those who have questions about open records, one of the things we want to stress tonight is if you have a question or a concern or a problem, give us a call so we can see if we can resolve it before escalating to another level. We also have Ms. Harper, who is a resident, but she works for the CDRA department. We have Mr. Sam here, who works in the city attorney's office, and Ms. Robin Bryant, who is not open records, but GICC coordinator for the police department, title. And I didn't catch your name, but I know you just started yesterday, right? 2 weeks ago. Okay, Sydney. Sydney's also the open records coordinator for the police department. So I wanted to make sure I recognized them so that you know what the team who is here to respond to your questions. As I stated, the purpose of this meeting is to give you information and to provide all the resources that are available. City receives over 9,000 open records requests in 2023. Well, 10 times more than, I think, outside of Atlanta, any other jurisdiction. So far, as of June of 2024, we have 4,000. So we're on course again to reach approximately 9,000 again. 85% of those are in public safety, primarily the police department. So that's a tremendous volume. So it's very imperative that, we try to get information to you. We brought in an outside expert in open records tonight to give you some information. But before I introduce her, I just want to let you know what the city is doing. So, and I have to give credit to our city manager, Ms. Sharon Subadan. She's been here a little bit less than a year, but since she's come on board, she's made this an emphasis and stress to the department directors the importance of providing open records. Ms. Subadan doesn't report to me. I'm a direct report to the council just as she is. But we have to work together, and the department directors report to her. So, she has made it a priority to her directors that you need to respond to these open records requests in accordance with the Open Records Act. So I want to make sure I say that. Additionally, by ordinance, we have to have training for our staff once annually. We had a training in February of this year, and our goal is to have it actually quarterly to ensure that our staff has up to date in terms of the latest things going on with open records. And then lastly, with the 2025 budget coming up, we are looking at getting additional resources to make sure that we stay on top of it, because one of the issues we had last year is staff turnover. And if you have staff turnover and people are not addressing it, then you run into problems with compliance. So 2024 has been a great year for us, and we look forward to making the rest of this year in 2025 better. So I didn't mean to talk this much, but I wanted to lay that groundwork, and it's my pleasure to introduce Attorney Susan Moore. Attorney Moore was the former general counsel for the Georgia Municipal Association, who we look to for training in all aspects of municipal government. So with that, I'm going to turn it over to Attorney Moore, and she's going to lead us into a discussion about the Georgia Records Act and then the city's process. And I'll get it back here for you. Yes.
Okay, usually when I do these, I wander around, but I notice y'all have cameras for streaming, so I won't do that. Okay? Okay. As Corey said, my name is Susan Moore. I'm a graduate of Georgetown Law School. I joined GMA in 1994, was Associate General Counsel for 6 years, and then General Counsel for 19. So I have a lot of experience with this. There is a publication on GMA's website, by the way, about open meetings and open records. If you ever want to look at that, it's freely available to the public. There's also information on the website of the Georgia First Amendment Foundation. Those are two good resources for government in the sunshine information. Always check the date to make sure it's up to date, because the legislature does tend to tinker with the law, and so you want to make sure you've got the latest information. Next slide. I want to let you know today the purpose is to provide information about the Georgia Open Records Act and the procedures specifically here in South Fulton. This is not advice. You're getting all the disclaimers now. This is the lawyer stuff, okay? It's an educational presentation only, not legal advice. I don't have an attorney-client relationship with any of you people, okay? I don't want to get in trouble with the bar, so I'm just putting it out there, okay? We all good? If y'all got questions, it's just education. So the focus, first we're going to do an overview of the state laws on open records, and then we're going to talk a little bit specifically about how to get records from South Fulton. And hopefully we can go through the website where your forms are, and those who aren't familiar with them can see those and see how it works. Y'all actually have a really good online system by comparison. I've seen a lot of places, and most places are like, send us an email, or they may have a very rudimentary form online, but they don't necessarily have the tracking and the feedback that your system does. I was actually kind of impressed when I saw it. So we're going to start here. These two quotes that come directly from the Georgia Constitution, and they set out that all government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. And that's in Article 1 of the Georgia Constitution. So it's an important principle that the legislature and the governments keep in mind. The next one is that the people of this state have the inherent right of regulating their internal government. Government is instituted for the protection, security, and benefit of the people, and at all times they have the right to alter or reform the same whenever the public good may require it. I like to start with these quotes because I think it's important that people understand the importance of getting records to your ability to regulate your government, ask questions of your government, and reform your government as necessary, and how primary this is in the Georgia Constitution. It's right there in Article 1, Section 2, both of these quotes. This quote, which is a much longer one, is at the beginning of the Open Records Act itself. It is actually Code Section 50-1870, subsection A, and it lays out the intent of the legislature. And you will see what I put in bold is the General Assembly finds and declares there is a strong presumption public records should be available for public inspection without delay. This act shall be broadly construed to allow the inspection of governmental records. Any case I've ever seen, almost every court cites to this section. They will also note that the exceptions to openness are to be narrowly construed. We're going to go through some of the exceptions. There are a lot of them. They tend to come up piecemeal as things sort of happen. The legislature responds, and so that's why they look as specific as they are when we get to them. They are in response to specific things that happen. So here's the sort of layout for tonight. I'm going to go through some of the definitions that are important in the Act, talk about what records are covered, talk about exempt information and records, because there are times when the record itself is available, but there may be information in that record that's not. Very private information, a person's social security number, things like that. How do you request a record? What is the state law and the city's response? What are the specific procedures here in South Fulton? How do you enforce it if there's non-compliance? And then we'll see what kind of time we have for questions, if y'all have questions about anything I've gone over, okay? So that's the general rule. So what's a record? Basically anything that is created or received by the city or the city officials or city employees in any format in the course of city business. So the real test here is whatever it was it created in the course of the city's business? We're not talking about things that are personal, right? We're not interested in that. It's just if it was created in the course of city business. Doesn't matter what format it's in. It can be a hard copy piece of paper. It can be something electronic. It can be a picture. It can be a recording. It can come in any format. It also doesn't matter where it is. Sometimes requests come in for things that are on people's personal electronic devices. And that could be a laptop, a tablet, a phone, things like that. It doesn't matter that it's a personal device. What matters is, was the record created, received, is it maintained in the course of official business? Is it about official business? You send somebody a text saying, how about them Braves? That's not exactly official business, right? But if people are talking about something that's an agenda item, that probably is public business and it needs to be saved. Also, material received or created by someone other than the city, including a private party who is performing a function for the city. So if there is a contractor, maybe they're building a building, right? Or they're providing short-term employees, temporary employees to help with something. The records of that company with respect to that area is going to be open. It's only going to be what's relevant. Again, if you're making records requests for City of South Fulton, the temporary employees from South Fulton, the construction work that they're doing for the City of South Fulton. It's not going to be for the company as a whole, but just for those things that they are doing on behalf of the city. Okay. So, what is considered an agency, and why do we care about this? We care because agencies are the ones who have a duty to respond. So, an agency covered by open records, it includes state and local governments. By the way, not the Georgia legislature. I just want to point out that little piece of irony. But it's state and local governments, departments, commissions, boards, offices, and authorities. So to the extent that the city has any other boards, the Ethics Board, a zoning commission, development authority, code enforcement board, all of those, they are also covered by open records. They're also covered by open meetings. That's a whole nother can of worms. Covered records. Some of these are going to be very obvious, and some of these are readily available on your website, on the city's website. Ordinances, policies, approved minutes and budgets, emails, texts, correspondence, recordings, personnel records, records that involve individuals. You're going to see, we're going to talk about, they get redactions. There's information that comes out because there are things that the public is entitled to know, but they're not entitled to know things that could result in identity theft. And kind of think of it that way. That's the kind of information that comes out, is if it's over personal. People may be sharing that information on their own social media. That's up to them. But the city records, that information is going to be blacked out. The term we use is redacted. So it's either going to be covered up when it's copied or taken out in some other way. Initial police arrest reports and initial incident reports are open records. So these are the first reports that come in. There, again, are some things that get redacted out of them. It is later reports. We're going to talk later about accident reports, you'll see. But the initial police arrest reports and incident reports are open records. And by the way, there's a whole nother set of rules about mugshots. I don't know if y'all know that, but there's a whole nother set of rules on that. So the rule for open records is always it's open unless it is specifically excluded. If there's not an exclusion that applies neatly, cleanly, where you don't have to shoehorn it in, then it's open. If there is an exception, then we apply it. Records. Those that are required by state or federal law to be held confidential. For instance, health records on city employees are confidential. Certain tax records, they're confidential. If state law or federal law say you can't give it out, you can't give it out. Medical or veterinary records and similar files. By the way, I've always been curious about how veterinary got in there. I don't know. It was there when I first started working in this field. I've never seen one. I've never seen a request for veterinary records, but it would be denied anyway, so I guess it doesn't matter. But it's medical or veterinary records. And similar files, the disclosure of which would be an invasion of personal privacy. So if somebody was asking for leave due to a medical condition, those are the kinds of things that wouldn't be covered by open records. You're not entitled to it. The person whose record it is, they can get it. If it's about you, usually you can get your own record. So that's always something to remember with respect to the redactions. If it's about you, you can get it. Records of pending investigations or prosecutions of criminal or unlawful activity. So if there is an ongoing investigation or prosecution, the records about that are not open. The question there becomes, when is something pending, particularly when you're dealing with things like cold cases? Is it still pending? And usually the courts have to weigh in on that based on what the investigating body is actually doing. For criminal prosecutions, it is open once it has been taken to its final end, including any appeals. So at that point, if somebody wants to see the files, they can see the files. And again, initial arrest and incident reports are open. The Uniform Georgia Motor Vehicle Accident Report. Someone was identified as the person from PD. Who was that? You. Y'all. You probably get a lot of requests for those, right? That's your big ones. And those are generally open, but there's a whole list of people who can get them, and it's only those people that can get them. So again, if it's your record, if you were the one in the accident, you can get a copy. If it's your insurance company, they can get a copy. If it's a witness, if it's an attorney for one of those, for one of the drivers or passengers, or for one of the insurance companies, they can get them. Why do you think that is? Back in the day, the legislature didn't want attorneys and others, medical professionals, getting these records and chasing people down to get them as clients to file lawsuits or get medical treatment. So ambulance chasing, for lack of a better term. And as you go through the exceptions, you see there's a reason for each of these. There was something that happened, and that's what sparked it. Real estate appraisals, engineering or feasibility studies are relative to acquiring real property. So if this is not open until either the acquisition is completed, terminated, abandoned, whatever. And the reason for that is you don't want people running up their price on the city. You want the city to have a fair chance to participate in the marketplace and to talk to the property owner and get a good price on the property, a fair price, and to have engineering and feasibility estimates that don't expose necessarily what the city's doing. I will point out that in many instances, you already know this, where the city's going, because they're usually comprehensive plans, recreation plans, transportation plans that lay all this out. And if you're paying attention, you'll see where might the city buy property for another recreation center? Where might they buy property for a library? It's usually pretty easy, but those are closed records. Sealed bids or proposals and related cost estimates. Again, this one's obvious. The whole point of the sealed bid program is for people to compete with each other. The bids are sealed until they're opened. At that point, then people can see them. If the government decides to abandon the project, then they also become open. So it's while they're in this process that they're closed. Because again, you don't want somebody to see someone else's bid and undercut them when that's not how the process works. Trade secrets or computer software. So whatever software the city is running, somebody can't get a copy of that by they have to go buy their own copy of Microsoft Office. It may be a process that they've developed, it may be client lists, it may be other things like that. What they have to do is they have to mark them as trade secrets so that the city government employees who have to respond know that the company regards this particular thing as a trade secret. And then the city can exclude it. And I'll tell you what I always did in these instances. If I got a request for something that's a trade secret, I would say to somebody, you know, we got this request. If you want to go get a protective order to the company whose trade secret it is, you go to court and you get a protective order. If you haven't marked it as a trade secret, I'm handing it out, okay? If you've marked it as a trade secret, I'm going to keep it back. And then you let the person who requested know, here's what we've got, here's what we're providing. In my experience, the person whose trade secret it is will usually take steps to protect it, so the city doesn't have to get too much into that. The other thing is that in contracts, I always make sure to say, if you have trade secrets, you have to mark them, and we are not responsible for what happens with them if you don't mark them, okay? It can just say trade secret, yeah, and that's typically, they don't give you a lot more detail. It's usually just marked that way with trade secret. It tends to be also things on the whole that are complicated. Sometimes companies can be overbroad with that, which is why I like to toss it to them to go defend it, and defend it being a trade secret, because I don't know if it really is or not. You know, if I'm the city attorney, they've marked it as one, but I don't really know. So, you know, you the company, you don't want this out, you know, go get a protective order. Go to court, protect it yourself. Records that are subject to the attorney-client privilege. Again, the city has the right and the necessity to consult with an attorney and to get legal advice. So records that come from that legal advice, those kind of records are not open because the city needs to have their lawyer give them candid legal advice. I also work as a city attorney. I represent the lovely community of Pine Lake. I don't know if anybody's familiar with that, in DeKalb County. We have 750 people. It's a lovely place. I encourage you to come to our festivals. But, you know, the materials that I send them, where I'm giving them a legal opinion on something, that's not covered. A lot of things that I share with them are going to show my thought process and things that I'm talking about. I communicate a lot with the city manager. That's how we do things there. And so if somebody wanted those emails, we're going to tell them no. Those are privileged. It also goes to confidential attorney work product, which is something that is slightly different because it may not be a direct communication between the attorney and the client. It might be someone who's been engaged by the attorney to do something because they are pursuing a particular legal theory or investigating something, and they want information back on that. So that may disclose the legal theories that they're thinking about, and again, it would be confidential. Confidential evaluations submitted to or examinations prepared by an agency in connection with appointment or hiring of public officer or official. So if there's a test somebody has to take, that's not available. When it talks about confidential evaluations, what they're talking about there is being able to go to someone's previous employer and talk to them and say, what do you think about this person? Do you think we should hire them? And the reason the exception is there is you want that person to be honest. Because if that record's going to get out, they may not be honest. So you want them to tell you the truth about someone who they're going to hire, someone the city is thinking about hiring. This is another one that typically comes up a lot. The bottom one, material obtained in an investigation of a complaint against a public officer or employee until 10 days after it's been presented to the person or agency who's going to make the decision. So here we're talking about any kinds of complaints. It could be a sexual harassment complaint, a discrimination complaint. It could be a complaint about somebody being unprofessional or rude, or it could be a complaint about criminal conduct. I think so-and-so is engaging in this. Whatever the complaint is, it is not open until the agency gets a chance to investigate and then turn that investigation over to whoever is going to make the decision. So in the case of employees, it could be the city manager, it could be their department director, it could be whoever's going to make the decision. 10 days after it goes to that person, it can become public. Again, you don't want to interfere with an ongoing investigation, but you do want to have a reasonable limit when the public can know what's going on here. So, records identifying persons applying to be executive head of an agency. And I put that in quotes because, again, you have to go back to what is the definition of the word agency. And when you go back, you'll see that it includes maybe department heads, the city manager. People who are at a high executive level is who we're talking about. But 14 days before the agency meets to vote on a position, the documents on up to the 3 best qualified candidates are subject to inspection. And this is a somewhat complicated exemption in that you get an opportunity also to go to the people who aren't going to get the offer. Because usually if you've got 3, you may have 1. I don't know how many people have done hiring, but that's kind of how it's run for me. People sort themselves out pretty quickly. And so you can go to people whose names might be disclosed and say, look, we're planning to make the offer to so-and-so. If you would like to withdraw, you can withdraw, and then their record does not become public, and their name does not become public. And that way their current employer doesn't know they're out looking if they choose not to tell them. So all of these, again, when you look at them, you might think, what's up with that? But there's a really good reason when you sort of poke behind it. But 14 days before the agency meets to vote. So city manager, community's going to be interested in that. What about this person? What kind of records did the city get about this person? And that way the community can see who's going to be coming in as executive head of an agency, and they can provide their feedback before the agency actually votes. 911 call records. And I understand for y'all, 911 calls are going to go to Fulton, correct, Corey? Okay. And that makes sense. Most cities don't run their own 911 centers. Some do. They're not nearly as many. Most times it's the county that runs it. But 911 calls that would reveal the person placing the call, if they're a confidential source, if it would endanger them, or reveal confidential information or surveillance. Also, if on that 911 call, There is somebody who is in distress, who is screaming, right? Or who dies during the call. Or there is a minor who's on the call. All of those exempt the record from production, okay? And when you think about it, that's really to be respectful of the families, be it the parents or the family of the deceased or the person who's in distress, because a 911 call is involuntary, really. It's something you do because you have to do it. It's not really much of a choice. There are people who can get these records, and included among those certainly are any criminal defendant and their attorney can get those records. So they can get the full record because they have a duty to defend the person, anybody who may have been accused in a crime. So, law enforcement records. Did you have a question, ma'am? Yes, ma'am. People may have allowed that to happen, and oftentimes they don't contain those particular things, or they're deemed not to contain that. Somebody didn't die, there's not a minor. They don't think the person is sufficiently in distress for it to be outside the realm. And we're going to talk here about recordings, because this is video recordings. The other thing is that from other states, they will have different rules. So definitely other states, they will have different rules, but those are the rules in Georgia. On law enforcement recordings, and here I'm not talking about like calling a 911, we're talking about body cam and dash cams, things like that. If the recording is made in a place where there is a reasonable expectation of privacy and there is not an ongoing investigation. That's the language that's used. So what are we talking about here? We're talking about perhaps a body cam in somebody's house. It doesn't result in any criminal charges, there's no ongoing investigation, and it's a place where someone would have a reasonable expectation of privacy. They're not in public, okay? Something in public, you're not gonna have a reasonable expectation of privacy. Another one might be if someone's in a hospital, where they wouldn't expect to have a recording become public. Also, these recordings can become public once the matter goes to trial. Those things are gonna start coming out because they're gonna become evidence. They're gonna come out in other ways. They're not necessarily gonna come out through the city as open records. They're gonna come from other parties, like defense attorneys and prosecutors and people like that who have access, but they're not covered by open records. So those law enforcement records, again, most of them are open. When do you close it? If there's this reasonable expectation of privacy and no pending investigation. So if there's a pending investigation, it can be on the news, it can be wherever. Now, the record where there's a reasonable expectation of privacy, that can be obtained by the representative or attorney of a deceased person or a minor who's on that record, or the accused in a criminal case, a civil litigant, or a potential civil litigant if relevant. So somebody may be claiming that their rights were violated, and they're going to bring a lawsuit saying that their Fourth Amendment rights on search and seizure were violated. They can get access to that. Again, it's probably going to be them on the recording, so it's sort of a matter of being able to get your own record. It kind of goes back to that. There is a code section that mandates an additional $10 fee for a copy of video from a law enforcement body cam or vehicle. I honestly don't know why that's there. It just is. So this information, if it's found in any record, it doesn't matter what kind, it gets taken out. The record itself may be produced, but this information is coming out. And when you look at it, you're going to know what it is. This is all stuff that somebody could use for identity theft, right? You don't want to facilitate that, so this stuff is not covered. Now, it's interesting because the exceptions undermine that somewhat, and I'll explain that. So what kind of stuff, go back, please. Yeah. we're talking social security number. Honestly, I never give mine out. I see it on forms, like at the doctor's office. Just because you ask me for it, I'm not giving it. But that's my rule on all information. You can ask, but you don't necessarily get. So, social security, mother's birth name, credit or debit card information, utility account information, their number and password. You can actually get certain information about utility accounts, and there have been cases about this when there have been allegations that elected officials were getting special treatment, like with water. There not being water cutoffs or something for elected officials or their family and friends. You can get the information about the account usage. You can't get things like the number. You can't get certain other information about it. But you can find that stuff out. Financial data, you know, somebody's bank, insurance or medical information. Again, that all comes out of the record. Personal email address. Now, that's a relatively new addition for obvious reasons. We didn't have personal email addresses, so those come out. Cell phone number and their day and month of birth. Again, all tied up with identity theft. Yes, ma'am. That's on the, I don't know why it's not on that one. That is the one for regular records. That does apply to public employees. You'll see that. There's actually a whole separate section that applies to employee records, but I don't know why it's not on there, but it's not, you know. But you could probably get the legislature to add it. Honestly, given doxing and things that happen to people these days, it's probably not a bad idea, but it's simply not on there. So this information is redacted, okay? The remaining part of the record, if there is any, is available. So this information gets taken out. Again, the exclusion doesn't apply if the person is requesting their own record, right? If law enforcement requests it, so if law enforcement is looking for somebody, they can get that kind of information. Credit rating agencies, they got a big pass on this. They get everybody's info. You know, they came, they asked, they got an exemption. And there are a few others that can get it, that get very, very obscure and specific. The one that I find interesting is kind of this next one, which is the person, someone who says they are with a news gathering organization who wants this information. And again, we're talking specifically about that information that is redacted out of a record. Social security number, financial information, account information. So if someone says they're with a news gathering organization and they're going to use this information for news gathering and reporting purposes, they have to sign an affidavit that says this. And why does signing an affidavit matter? Because false swearing is a felony, okay? So they have to sign an affidavit. They have to kind of stick their neck out and say they're doing this. They can receive social security number and day of month of birth for people. I think the reason there is to be able to verify when somebody's being referenced or talked about that it's actually that person, to kind of cross-reference. But this is the exception that exists in Georgia law. What is a news gathering organization? I can't tell you. We asked that question at the legislature when this was going through. I was one of the lobbyists for the Georgia Municipal Association. And, you know, the committee that was hearing it, which I think was Judiciary, they gave us a big, So I don't know what a news gathering organization is. I guess we'll find out someday. The ability to get social security number and day of month of birth for a news gathering organization does not apply to public employee records. It just doesn't. So for a deceased individual, again, their day and month of birth and mother's birth name is not redacted. I find that very odd. I mean, again, to me, it looks like a recipe for identity theft. I don't know why it's in there. I'm sure there's a good reason. But in any event, if somebody's dead, their information to that extent is available. Go ahead. So for public employees, and this is in employee records, so personnel records, not city records. If you're a city resident and you've got records like of a water account or other accounts, you know, that's going to be handled under the other exception, because whoever's dealing with that may not know that you're a city employee. But there is a separate section for employee records, and this is the information that comes out, and it includes home address. It includes personal phone number, day and month of birth, social security, insurance, mother's birth date, all this kind of same stuff, financial data other than compensation. If you're a public employee, the public is entitled to know how much you're getting paid. They are not entitled to know how many exemptions you have, or, you know, other information like, are there liens on, is there a garnishment, things like that. They also can't find out the identity of family members or dependents. So if you have family members listed as emergency contacts or for your health insurance or other benefits, that is also not public, okay? So that's the information that comes out of a public employees' records, their personnel file. Next. Requesting a record. A request can be oral or written. So you can go into the clerk's office or other departments and you can orally ask for a record. I expect if you went to the clerk's office and asked for something like an agenda or meeting minutes or something, that's probably something they can produce and give you rather quickly. It's probably readily to hand, would be my guess. Most requests are done in writing, and if my understanding is right, y'all input the oral requests. The employees do that. If they get an oral request, they input it into the system as a measure of keeping track of the requests that are made and the responses that people got, which is a really good and important thing to do. Why would you want it to be in writing? You want it to be in writing because then you can use the enforcement provisions. If it's an oral request, you don't get to use those. Why? Because an oral request boils down to he said, she said, right? And in this day and age, it's just as easy to do a written request. It's probably easier. You don't have to come to City Hall. You can just do it online. So most requests are, these days, written. You make the request to the open records officer, records custodian, or other person that's been designated. This is my own tip. To expedite the response, be as specific as possible. You will see that there are cost estimates that come from requests, and if the cost estimate is high, you might want to consider revising your request. And I'll give you an example of this for when I worked for a government, and I worked for Gwinnett County a long time ago, and we got requests for accident reports along the entire length of Highway 78, okay? Somebody was interested in an accident, basically, and the traffic control measures at a particular intersection. But they asked for all the records for like 3 years. And I was like, dude, just tell me what you want, right? I mean, you're entitled to it. I'm happy to give it to you. But here's the thing, you want all that? That's a lot, because we get a lot of accidents, and I'm going to be throwing a lot of stuff at you that you don't care about. So just tell me what you want, and I'll get it to you. I ended up coming up with a form for that department that would say, I want information about within a quarter mile of this intersection or between these mile markers. We would try to get people to really think about what do you want, because then I can find it and I can get it to you, and I'm not going to be giving you a bunch of stuff you don't want. The city is not required to create records that do not exist at the time of the request. So this is actually an area where I see a lot of dispute, is the city will say there is no such record, and somebody will say, yes, there is. Oftentimes there's not. I know of a city, this was a long time ago, that got a request for records showing any contracts they had with the Disney company. And they didn't have any, not surprising, And they were like, we don't have any. But the person insisted they did. They didn't. So if it doesn't exist, then they don't have to create it, and you're not entitled to it. The city is not required to answer questions. A records request is not an interrogatory. Some people treat them like that. Tell me this, explain that. I want to know X, Y, Z. There's other ways to do that. It's not through open records, right? If you're a citizen and you have those kind of questions, feel free to write a letter. Contact your elected official. Contact the clerk. Arrange a meeting. Come in and ask questions. I encourage that. If you've got questions, do it that way. This open records is when you know what you're looking for the most part. You can go on a fishing expedition. It's just, I would say it can get expensive. So, city not required to create a record that doesn't exist. Don't answer questions. And I see many records requests that include lots of questions. Explain this, tell me about that. And the answer's gonna be, I don't have to. I'm not gonna. Make an appointment and come in. The city's not going to be doing research for you and writing a memorandum in response. The other thing, and this is kind of cheeky, but when I was general counsel at GMA and citizens would call me and be upset, I'd say, if you're upset, run for office. If you want to be part of the conversation, if you want to be the decision maker, get in there. And it was cheeky because, that's probably not a terribly polite thing to say, but it worked. So where there are electronic records that only require inputting things like a range, a search, a filter, things like that, right? There is a record and it includes lots of information. But the person only want it for certain years, right? If the city can put in those years and pull up those records, they have to do that, okay? If it's something that already exists and you can just pull it up with that. Or if you filter it, if it concerns, particular employees, and you can search using that and you can pull it up, okay? So if you can tailor the record using these search parameters, then yeah, you create a record. But basically what you're doing is you're taking an existing record and you're applying the request to it and giving people what they asked for instead of the whole record. So again, if there are those kind of electronic records, that has to be produced. And it has to be produced in the form in which it's ordinarily kept. I've seen this too with people requesting information in a specific software, and it might not be software the city uses. And the city doesn't have to do that because that's not something they have the right to use. They have to produce it in the form they have it, but not a specific form. Yes, sir.
So when you're told that the record exists,
Under open records it is, yes. And I'll point out that when we talk about enforcement, you're going to see that the Open Records Act and enforcement talks about knowing and willfully withholding records. There have been times when people don't know that there's a record. They've looked for it, but they haven't found anything, so they're telling you it doesn't exist. There might be something that they missed, but they're not doing it intentionally or willfully. I will point out this with City of South Fulton, something y'all have that is somewhat unique in being a new city, is that you don't have storage sheds full of paper records going back 100 years. And seriously, there are a lot of cities in Georgia that have that have paper records that have never been digitized, that are sitting in a shed somewhere, and somebody may have to go find it. So, City of South Fulton, most of your records are probably already electronic, which certainly makes looking easier, or it should. If you're looking for something older about this area and you have to go to Fulton County, you might run into the boxes of paper records problem. So I'm just pointing that out. But if there's no records, that's the end of it. There actually is a case on point with that involving Governor Kemp's office, where somebody asked for records and they basically were like, we don't have those records. And the person kept pursuing it, and the court's like, they don't have the records. And that was their response. Now, in some of these instances, in my experience, sometimes people will say, we don't have those records. And then the requesting party will come up and they'll say, but I have this email and it shows that you do have this record. Okay? Well, again, it's a good faith issue. Did they look for it? Did they know? Is it on somebody's personal device that they didn't know? They asked that person wasn't forthcoming with it. That can happen. And then you go back and you look and you say, okay, are there any more records like this? So-and-so gave us this record. Are there more records? No. If the record doesn't exist, that's it. So, in lieu of separate printouts or copies, the city can provide access through the website. And again, y'all have a lot of stuff on your website. You've got a check register, which is open, where you can check city expenditures individually. You've got lots of budget information. You've got lots of reports. There's a lot of information out there. A requester can insist on receiving responsive data available on the website, but the city only has to provide it in the form that they already keep it. So again, if it's available on the website, maybe it's the check register information, and you're interested in certain purchases, right? You can get that information electronically if you don't want to get it through the website, but the city will pull it down and give it to you in the way that they keep it. So they're going to apply whatever record-keeping format they use. Again, that's in the course of business. How is it done in the course of the city's business? If the city declines to produce a record or takes information out of a record, it has to cite in its response to the requester the code section and subsection that allows for that exemption from disclosure. So that has to be cited in there to tell you. So if you're the person requesting, you can look at it and you can say, oh, they're telling me it's 50, 18, 72, 14, or 21. 21 and 22, I think, may be the individual records. But so they're telling me it's that. And you can go look it up. The Georgia Code is available online for free. The website is legis.ga.gov. You can also track legislation there, but you can find the Georgia Code there annotated for free. So, next slide. The city has to produce responsive records in a reasonable amount of time, not to exceed 3 days. And that's 3 business days. The 3 days start on the business day after the request is received. So that's when the clock starts running. Again, business days, weekends, holidays, things like that are not going to be included in counting the 3 days. If the records are not going to be available in the 3 days, the city has to provide a description of what is responsive and a timeline. Again, this would be most applicable if somebody is requesting something that requires searching for things, asking people for records. I need you to go find this, or a lot of records, or there has to be a lot of redaction. That's the other thing that's going to cause records not to be produced in 3 days, but a timeline is when I can give you all these records, but I got to take all this stuff out. That's going to take us a little time. Here's when they'll be available, okay? Again, places that have boxes of records in sheds, they run into problems with this. Yes, ma'am. Yeah, I'm going to get to that next. But yeah, that's definitely an issue. So if there is searching, if there's redaction, if there's things like that, that may push out the timeline from 3 days. Yes, sir, that's okay. The reply. Yeah, Although, again, if you look at it, it says responsive records in a reasonable amount of time not to exceed 3 days, okay? Again, if you're requesting something like an ordinance, again, it's available online, your ordinances are, or an agenda or meeting minutes, that shouldn't take 3 days. I mean, I just don't believe that it would, because those are the kind of things that should be readily available, right? They should be close to hand. They're probably organized, cataloged, things like that, so that they can be easily found. I mean, I would expect most times if somebody came in and said, I'd like, you know, an agenda for the upcoming meeting, that would be something that could be produced pretty quickly and handed out and over and done with. There's no 3 days, there's no nothing. The person getting the request would write it down and put it in your system to track it, but it would probably just be, here's that record because it's right here. Yes, ma'am. I'm not aware of one, but again, the prevailing factor here is reasonable. So what is reasonable given whatever this record is? You know, why is it not available now is going to be the driver. And then the other part of it is it may not be you that have the record. It could be somebody else. Could be, again, Fulton County might have some records, like land use records from before City of South Fulton existed. Those are going to be with Fulton County. Those are not going to be with the City of South Fulton. And so the response would be, we don't have responsive records. That would be the city's response. Fulton might have them, but we don't. Also, you might have a contractor that has them. And sometimes getting records from contractors can be like pulling teeth. They don't always want to share, and sometimes it helps to get the city attorney involved to make a call. But, you know, I'm an attorney, so that's what I do. Yes, ma'am. Mm-hmm. Right. Right. Absolutely. Yeah, I understand. 3 days was put in there, you know, basically, it's a very short time period compared to other state records laws. I will say that. It was put in there when Roy Barnes was governor. Before then, it just said a reasonable amount of time, and it didn't say 3 days. My own supposition is that, you know, it was a campaign thing. You know, yay me, I'm for open records. But that's me, that's Susan. I'm probably going to get in trouble for that. I don't know with who, but anyway, that's when that 3 days came in. Before that, it just said a reasonable amount of time is what the statute. I don't know what happened to somebody that they felt like 3 days. I do know part of the reason was being able to get people information contemporaneously with ongoing events. So if you're looking for something historical, yeah, it's going to take more time. If you're looking for something contemporaneous, it'll probably take less time, I think was the idea. Yes, sir. Yeah. Mm-hmm. No, you need to go to Fulton because they're the one that has it. South Fulton doesn't have it. They didn't have any entitlement to it. All of those records, it's on Fulton County to maintain them, and so it should be with them. And that's where you need to go. I don't know, Corey?
Actually, in the system, if that is the case, you should receive a letter that says, well, we are not the holder of these public records, but you can contact such and such. And to that point, we do have some Fulton County records, but the majority of them are still with Fulton County, and we're in conversation with them to, at some point, take possession of those. As you know, since Fulton County goes way back, it's a voluminous amount of boxes that we have to come up with a strategy and plan to receive those and store them and digitize them at some point.
There isn't a file is allowed to be, you guys can.
Yeah. Yeah. There are going to be times, and also if there's a contractor, and it might be this contractor has those records, here's who it is. And again, under the definition of agency, remember, that contractor, to the extent they're doing that public project or acting on behalf of the city, those records are open and they should be turning them over. So you can go directly to that contractor as the agency, rather than rely on the city to try to wrestle it out of them. So again, it talks about using the most economical means reasonably calculated to identify and produce responsive records. The city can charge for search, retrieval, redaction, production, copying. But again, they're supposed to use the most economical means to do that. The first 15 minutes are free. So you get 15 minutes, and again, that will cover most requests for things that are readily at hand. If there is a zoning issue or something, and that application or the application for a special use permit is sitting right there, it's coming up at a meeting, it's probably already part of an agenda. That should be something easy to produce because it's readily to hand. It's not something you have to go look for, or you have to figure out what is this person really looking for. Now, the charge for search, retrieval, or redaction is limited to the prorated hourly salary of the lowest paid full-time employee with the necessary skills and training. And your city has a website, on their website, has that rate posted, and it's done by department. So you will know what that hourly rate is. I will say that you don't get to charge for attorney time, because I'll tell you this as somebody with clients, I want to see what's getting redacted out of those records and make sure it's right, okay? But the city can't charge for my time. They can only charge for these other employees. They can't charge for the attorney, even though I might be the one doing it, okay? The charge for search, retrieval, or redaction cannot exceed 10 cents per page. And again, this is usually going to be copying for letter or legal, or the actual cost of other documents. So if you're looking for plats, like this gentleman mentioned, those tend to be oversized. You may have to use special equipment to copy them. And so you can charge the actual cost for that rather than just 10 cents a page. For electronic records, the city can charge the actual cost of the media. So if somebody wants it on a flash drive, if somebody wants it on some other medium, back in the day we had discs. I don't know if other people remember that, but when I was at GMA, the attorney that worked for me actually laughed when I pulled one out of my desk, and he really had never seen a floppy. He was really amazed by that. He's like, y'all store? I'm like, shut up, go away. So, but the other interesting thing there is hopefully Fulton County doesn't have stuff stored on that media because you can't read it anymore. If stuff is on some of that stuff, it's as good as gone because there's no way to read it. Again, South Fulton came into existence, 2017? So, I mean, lucky being here with the electronic age, and you don't have things stuck on microfiche, right? Which probably does exist in some places. So, if the city estimates the cost of records is less than $25,000, you're going to get notified of the request, of the estimate, and the city's going to get the records together for you, okay? And trust that you're going to pay it if it's less than $25. If the city estimates the cost is $25,000 to $500,000, you're going to be notified of the estimate and asked to agree to pay that amount. They don't require prepayment. So again, it's an estimate. If the actual cost is less, then that's what you get charged. But you're asked to agree that that's what you're going to do. this, if the estimate is too high, is a good opportunity to say, okay, that's too much. How do I revise this request? I really only want to pay X. And whoever department you're dealing with, maybe they can help you find a way to frame your request so that's what you get and that's what you pay. Again, you don't need to ask for a bunch of stuff you don't really want to try to play hide the ball. I don't want them to know what I'm really looking for. You're entitled to the records. Just ask for them. If the city estimates that the cost of records exceeds $500, then the requester will be notified of the estimate, and they will be required to prepay it before the city goes and starts pulling records. Why does all this exist? Because in the past, people made very voluminous document requests, and then they either didn't pick them up after a lot of work had gone into them, or they didn't pay for them. So that's why these exist. And as I've noted before, many records are available on the city's website. Minutes, agendas, budgets. Again, y'all have the check register there. You can see expenses basically as they happen. Land use permit and zoning requests. I was looking through your site. Man, y'all got a lot of stuff out there. Updates on projects. So there's a lot of stuff I would suggest before making a records request. I'd first go and I'd just see what I could find, but that's me. So, you know, but it might be what you're looking for in there. So to minimize cost and delay and help craft a more specific request, again, you may want to see what's online, and that might help you frame your request too. What do they call these records, right? How are these records kept? So that you know how to ask for them in a way that makes it quick for the employee to go get it. Because it helps if you're speaking the same language, right? So can you pull that up? No, I wanted to, if possible, go to the city's website. Well, let's go on through the rest. We'll do it at the end. How about that? Well, let's just go through the rest. Sorry. That way we can go through the record stuff. Okay, next. Okay. In general, your records office is the city clerk, police, fire department, municipal court. You need to get those from those departments. And municipal courts are going to have their own rules, by the way, that are also established for the courts. So just be aware of that there are going to be things they're going to have to redact out also. But they will be able to give records like someone's disposition, right? What happened with their case? They can get their disposition record. Because they may want, you know, to seal that file, or what we used to call expungement, take it out of the system, if you will. So, resolving records disputes. The response within 3 days should identify which responsive records are known to exist. Again, this goes back to the issue, if it doesn't exist, it doesn't exist. And it's known to exist. So if people are playing hide the ball with the staff, that's a whole nother issue, okay? If people aren't telling staff that they have these records, that's a whole nother issue. But if they're known to exist, there should be a timeline for production if they're not currently available. So, you know, we think this record, here's what we're going to get first. These records, we think it's going to be this many sheets. We think it's going to take this amount of time to prepare it, and it'll be done next week. And then maybe there's a second tranche of records. These records, they're going to take longer, and it's going to be this many pages, this much redaction, and here's the estimate for that. So it's also, again, maybe a good opportunity to adjust a records request to make it fit your needs and budget. They also, at that time, have to tell you of any authority for redactions. And this goes to your issue, because it can be tricky in the 3-day period when you don't really know what the records are, right? To cite all the redactions. You have to kind of think about it. What do we think is in these records? how did they ask for information in the past? You know, in the past, I think people used to ask for social security number a lot when they didn't need it. And what I have always told clients with respect to records and other information is, if you don't need it, don't ask for it, because then you don't have to protect it, and then you don't have to produce it, and you don't have to maintain it. So only ask for the information you need. This is advice to the city, unsolicited, but only ask for what you need, and then that's all you have to worry about. So with respect to forms and things like that, I think it's always a good idea to go through them and make sure you're not requesting information that isn't necessary. So if there's a third party, you should be told who that is. If there's somebody else, Fulton County, who has them, go ask Fulton County, you know. Again, because it's a relatively new city, records may not be here. And if there's a disagreement on responsive records, the cost estimate, or another issue, I encourage you to contact the open records officer to clarify. Make sure you're still talking about the same thing. Again, I've seen people get sideways because they're not actually talking about how the records are actually kept. And if you understand how the records are kept, you can make a better request. If there is a problem, the requester can also contact the Office of the Attorney General for the state of Georgia for assistance in resolving records disputes. They have an assigned assistant attorney general who handles that area. Any person or organization or the attorney general can bring an action in superior court to compel compliance. The complaining party, the person who sues, may receive their attorney's fees and other costs unless the court determines that the complaining party acted without substantial justification. I've seen one case where the court did say you acted without substantial justification because you're not getting your attorney fees, because they felt like the requester sort of jumped the gun and didn't follow up and didn't try to basically work things out. They were like, 3 days, haha, I'm filing a lawsuit. And the court was like, really? You know, go back and y'all need to work this out. And in this instance, there had been like a series of requests. And the court was like, that's not reasonable. So go back and try to work it out and then come and sue. Knowingly and willfully violating the Open Records Act, and this includes intentionally making them difficult to review or obtain, it can be punished as a misdemeanor. So it is a crime, okay? It can be a crime. It can be, the enforcement can be civil or it can be criminal, okay? It can be punished as a misdemeanor with a fine up to $1,000 for the first violation. Alternatively, the court can impose a civil penalty of $1,000 if they don't want to treat it as a crime. Each additional violation within a 12-month period could incur civil or criminal penalty up to $2,500 per violation. And it is a defense to a criminal action if the person acted in good faith. And again, this is the staff member who's asking for the records and somebody doesn't give it to them or doesn't let them know they exist. They acted in good faith. They did what they could. If somebody's playing hide the ball, that's really not on them. There was, and y'all may remember this case that came out of, I believe it was the city of Atlanta, where someone requested records and the department head got the records together and was ready to give them out and stuff. And the person over them said, don't give it to them. Make this as hard as possible. Delay. I mean, stupidly, she did it in text messages and emails. Right? That was my reaction, was like, really, you can't pick up the phone if you're going to do something illegal? But it was right there, just in front of God and everybody, saying, yeah, we want to delay. And the court was very unsympathetic. They really dropped the hammer on her. So, yes, ma'am. Mm-hmm. Oh, I don't doubt it. Yeah.
So that creates problems.
Yeah, I mean, if you don't have the records, you don't have the records. So if the request comes to you or the city, the answer is we don't have it.
We definitely don't have sewer records.
I mean, that's the simple answer. It would be nice, but this is not the place where that is dealt with. The Open Records Act is really about citizens getting information from their community. That's a whole nother issue with the intergovernmental. And I don't know if y'all could address that with your SDS or something, but it's just a thought. But that's a whole nother issue, and Open Records doesn't cover that. So that's the other thing. To the extent that there are things in Open Records that you find disappointing or not useful or not helpful, bear in mind this is one thing, one statute, one tool. There's the Open Meetings Act, you know. There are a lot of other ways to get information other than an open records request. Sometimes you need to do a records request. I'm a big believer in grown-ups talking to each other. And if you need something to say, I need this, please provide it. Or if you have a question saying, I'd like to meet with you to talk about X, you know. If you've got questions instead of you're asking for records, maybe you make an appointment with your elected official or the clerk or whoever's in charge of what you have questions about. But a records request isn't how you get that. So bear that in mind, that the Open Records Act is just one tool. It's just one thing. It's used for a very specific purpose, but it does have a lot of uses. And there's a lot of information that can be gained from it. So now we're going to look at how you make a request. You want to handle this? Yeah. Yeah. You could try, but the problem there is going to be everybody saying it doesn't exist. And Open Records doesn't cover it if they don't have it.
But they didn't say it didn't exist.
Right.
They said they passed it over.
Well, and so the answer might be, Fulton says they gave it to so-and-so, right? And honestly, my next question on that would be, show me any records on the transfer of records. Okay? I mean, that's how I would get at that, honestly, is, okay, you're telling me all this happened. Where's the evidence that this happened? And there may not be any. Again, there may not be records. This may have all been done with staff talking to each other and stuff getting sent, depending on when it happened, depending on the relationships between people, right? So, you know, if that's going on, I would look for, is there a trail that shows me where that record is? And if so, how would I describe that? What's the way to describe that so that the staff member who's looking for it, right,
It may be something,
knows what to look for?
I was about to say, maybe something simple. I remember that Fulton had a fire.
Yeah,
Some of their records were
right.
destroyed. And what Fulton County needs to say, we don't have the details of what happened.
We believe that they were destroyed in the fire. Right. And the same thing, I mean, places that have had floods, right? And they've had City Hall flooded. The good thing with electronic records, I will say this, is hopefully they can be stored in more than one place. Yeah, but with electronic records, you know, it's funny because people talk about the cloud like it's just the heavens, you know, and it's really not. It's physical servers in a physical place holding data somewhere, okay? So the cloud, you know, there is a server if somebody is pulling it up electronically. So, you know, where is that server? And, you know, hopefully the city is backing up records. I know some places that have agreements, and this may not be necessary with the cloud stuff, because if the city's records are being kept in Bingham, New York, right, if the server is there or something, it's not likely to be affected by the same weather and natural disasters and things that happen here. So the record is probably safe if it's not necessarily, if it's in two places, right? But, Yeah, y'all have some unique issues given the relative youth of the city, and who might have records. But again, if the city doesn't have the record, and they don't have the record, they can't make things exist that don't exist. They can't make things, they can't produce things they don't have, right? It's what do you have at the time the request is made? You know, that's the record I'm going to give you. That's what I have. I'm not going to create something. I'm not going to write a summary. I'm not going to aggregate 6 different records. I might give you 6 different records and let you aggregate all that information. But if that's not how we keep it, that's not how we're going to produce it. Yes, ma'am.
Going back to the question about the address information being public, so when you do, when you come to
Mm-hmm. Mm-hmm. Right. Right, and that, the home address stuff, if you recall, is in the personnel record. It's not in. No, but that's what I'm saying. Yeah, in that record, it's not going to be redacted. It's going to be there because it's not required to be redacted. Yeah, yeah. Right. My understanding of why that's asked for at meetings, and y'all may have another, is really to inform the council members so that they know the context of somebody's comments. They know, are you from a particular neighborhood? I mean, you know, why are you coming with this comment? I think it gives them context and also, at least with the city I represent, a lot of times they want to follow up. So they'll say, you know, Claire, let me call you back. That's a great question. I don't know the answer, but.
So my question is going into the discussion that it has to be added into the legislation.
Well,
so
but
would that be local or would that be
No,
state?
that would be
needs to-
state, because this is all state. This is all state open records. The state has preempted the field on this. It is the state legislature, to the extent that there are not federal requirements. Let me add that. So there are federal restrictions, things like HIPAA, you know, that you're familiar with because we get 4,000 forms at the doctor, right? So if there's a federal law, right? But there are a lot of exceptions we didn't go over because they're not probably things y'all are going to get asked for. There's stuff involving natural resources, agriculture, university records, all that kind of stuff. Since it's not really relevant to the city, I didn't bring any of that up because that's just going to get you in weeds you don't need to see. So you want to go over the...
Yeah, actually, Attorney Moore. But first of all, can you give Attorney Moore a round of applause for her presentation? I tell you, Attorney Moore, I've sat in on 3 different trainings over the last 12 months for open records, and every time I hear something different, something new in each one. So I appreciate your candidness and your straightforwardness. I didn't expect anything less. And what I was going to say is that most of the residents here have filed open records. So I know they know how to use the system. But what I would like to say is that one of the takeaways is that this is a two-way communication. I've heard a lot of things. I know a lot of you, and I try to be open. If you have a question like that or a problem with the open record system, please give me or my staff a call so we can have an opportunity to address it. I'm not saying we're going to give you the answer you want to hear, but what I will say is we're going to, try to find out what the answer is and get it to you. And if it's something that's a policy decision or needs to go above our heads, we will push that forward. Before I take any more questions, other council members did come in. See, Council Member Carmelita Gums and Councilwoman Helen Willis came in as well. And Councilwoman Keosha Bell said she was trying to make it as well. I hope you enjoyed the presentation. Attorney Moore mentioned the Georgia First Amendment Foundation, which produces a red book. It's free. If you go online or Google Georgia First Amendment Foundation, it gives you every rule within the Open Records Act as well as Open Meetings Act. It's a good resource to have. And like she said, this is from 2019. It updates frequently. The Open Records Act is a living law. I mean, it's always being updated. So that's why I said every time I hear a presentation, there's always something to say, I didn't know about that. So I wanted to say that. Secondly, on the table, we have a one-page Open Records 101, and then we also have Obtaining City Records. These documents go in depth. One is a little shorter. The other one is front and back that Attorney Moore helped us produce, and will be on our website. And the main thing we want to stress is that we want to get you the information. As the main thing she said is it's all public. It's all public. So there's no reason for us to intentionally try to hide any documents. And as long as I'm going to be the Open Records custodian, it's my duty and my obligation to try to get you those records, except when the city attorney, weighs in terms of those exceptions. So are there any other questions this evening? Yes, ma'am. It's okay. Okay. Well, that was her work product. If she releases it, then I don't. Okay. Okay. So yes. Yes, or contact me, Corey Adams. And that's the other thing I want to say is that, once again, my name is Corey Adams. You can email me directly, or you can email our Open Records email, orr@cityofsouthfultonga.gov, or you can contact anybody in my office, and we're more than willing to try to help you and get the answers that you need. Any other questions? Ms. Leverett?
Yes, if you do an open records request and it could be sent electronically, do you send it electronically, and is there still a fee?
There's not a fee to send it electronically, and that's our preferred method because of our GovQA. That's our electronic system. So that's why I have this up here. This is kind of a diagram of how our open record system works. The citizen sends the request. It goes to my office. It goes into the system, and then the system determines who is the custodial department. So that's the key word, that records aren't held in the clerk's office. Only thing we do is send it to that department that has that record. And then that's when the 3 days start. They have 3 days to try to produce it, say we don't have it, or we have it and it's going to take this amount of time to produce it. Then they submit it through the system back in there, and then we send you an email with a link to get your electronic record. And depending on if it's readily available, like she said, it'll be sent within those 3 days. If they have to search for it, redact, or anything like that, then we'll send you a letter saying we found documents. We'll get it to you in this amount of time, and this is the estimated cost. Any other questions? Y'all, look at that, 7:30. That's we had allotted an hour and a half. We're more than willing to stay here all night. If you have any other questions after tonight, yes. I'm sorry. Oh, if you have any other questions after the night, feel free to contact my office, and we'll get the answer. We'll contact Attorney Moore. She's one thing I like about Attorney Moore. She's a straight shooter. She doesn't have any. She's just giving you the law. So, with that, unless there's any other questions. Oh, I'm sorry, Ms. Johnson. Yes, ma'am. Yeah, right.
Yeah, so it belongs to the city. Okay. So city, we want another one. Y'all allow that?
Hey, absolutely. We can do it annually, quarterly. Mr. Snellings?
What is the method that you accept payment for open records requests? Because I went in the city hall before. Sometimes I take a credit card
Yeah, if that happens again, let me know. That's a training issue. We accept check. You can pay by credit card. The only exception is that they have to create an invoice in our financial system, and that's the step that some people miss. So that's a training issue, but credit card and check, we definitely can take payment. Mhm. Well, thank y'all for coming out. Y'all be safe getting home, and we'll see you at the next Open Records Town Hall meeting.